Good morning again. We reconvene this meeting, which is the 31st meeting of the Joint Select Committee on Finance and Legal Affairs. My name is Clarence Rambarat. I'm the Vice Chairman of the committee, and I'll chair today's proceedings. The committee is convening its second public hearing pursuant to its inquiry into the adequacy of the Magistrates' Court facilities. Our first hearing was convened on April 26, 2019. We welcome the representatives from the Office of Probation Services, Ministry of National Security, Property and Real Estate Services Division, better known as PRESD, from the Ministry of Public Administration, representatives from the Trinidad and Tobago Fire Service, and representatives from the Occupational Safety and Health Agency. I would now invite the other members of the Finance and Legal Affairs Committee to introduce themselves.
Good morning, all. I am Vidya Guiding Gopi Singh, member.
Good morning, all. Taharko Bika, member.
Thank you. There are three objectives of this inquiry. The first objective is to evaluate the conditions of existing magistrate court facilities in Trinidad and Tobago, to identify the progress that has been made by the judiciary in improving the facilities at the Magistrates' Court, and to examine the extent to which local Magistrates' Court are in keeping with international standards for layout and design. I now invite the representatives who are here to introduce themselves, starting with PRESD.
Good morning, all. Angela Lum Joseph, Acting Director, Public Management, Ministry of Public Administration.
Good morning. I'm Susan McLean Maxwell, Public Management Consultant, Property and Real Estate Services Division, Ministry of Public Administration.
Good morning. I am Carolyn Sancho, Executive Director of the OSHA Agency.
Good morning, Chair and members. I am Petal John Behrens, Deputy Director Legal of OSHA.
Good morning, all. I am Devki Sintra Maharaj, Chief Probation Officer, Ministry of National Security.
Pleasant morning, everyone. I am Jason Chartagoon, Acting Probation Officer, 3 stationed at San Fernando from the Ministry of National Security.
Good morning, all. I'm Anastasia Marchand-Lequent, Research Planning and Development Manager at OSHA.
Good morning, everyone. Arlene John Siao, Chief Inspector of the Occupational Safety and Health Agency.
Good morning. Darren Deason, Assistant Divisional Fire Officer, Acton, Northern Division.
Good morning, all. Name is Lal Chan Arujun, Assistant Divisional Fire Officer, Acton, Southern Division.
Thank you very much. Now, the committee has received written submissions from the different entities, and on April 26, 2019, the committee had extensive discussions with the representatives who were there on that occasion, and on the basis of both your written submissions and previous engagements on April 26, the committee will conduct an examination. I want to invite Ms. Gayadeen to open on behalf of the committee.
Good morning again. It is really no secret that the state of the magistracy, the buildings, are really dilapidated, for the want of a better word. We have issues with overcrowding. We have issues with the confluence of cross-circulation. We have issues with entrances and egresses. And basically, persons really, their lives and limb are at stake going to these magistrate courts. If you were to look at the magistrate court Siparia, or Sangre Grande, or Rima, they're all wanting in one aspect or the other. So my question to OSHA is that what is your relationship that you have with the judiciary? Is it that you go and have like routine appraisals of these buildings and maybe give them some notices or so? Because we have these buildings that are in this state, and from my information, I don't believe anything has been done really by OSHA, and perhaps you could clarify.
Good morning, and thank you. The Occupational Safety and Health Agency does risk profiling of the industrial establishment in Trinidad and Tobago. As such, we do visit various government agencies, government buildings. Currently, we have conducted inspections to the 26 facilities that are under the purview of the magistrate courts, as well as the different facilities that they have under their charge, which are like the accounting departments and other areas that they actually occupy. We have visited primarily because of a reactive approach, whereby we will get accidents, reports of complaints, requests from property real estate in regards to lease and rental. We will also visit based on requests under works of engineering construction, whereby we will go in. When we do a compliance exercise, we will identify non-conformance with the Act, and we have issued improvement notices to the various facilities under the judiciary. As such, saying that, what we have started doing is looking at our various government agencies. We have just completed compliance programs with the government ministries, and as part of our program, we have also corresponded to the master of the court, Master Allen, whereby we have requested, because of the role, the function of the magistrate courts, us just actually arriving there, clearly, it has to be structured. So they are in full agreement with the agency doing those proactive visits and complying, giving them reports on the non-conformance as it relates to the Act.
So when you give, I heard you clearly, so when you give these notices of compliance, is there any follow-through or follow-up, or is it that it's just left in abeyance?
Those notices, as it relates to improvement notices, are followed up.
The judiciary also has an internal OSH unit. Do you interact with that internal OSH unit too and collaborate with them?
Currently, as I said, the OSH team at the judiciary, we have been in contact with them, and they are currently developing a schedule based on the operations of the magistrate court and the sensitivity of the operations. So within the mid-July, we are hoping to commence that program.
And when these different judicial buildings, have you found any reason whatsoever not to shut down those buildings?
Once again, the aspect of risk is what we do our profiling on. The level of risk posed to the workers, the patrons who visit the facility is what will be identified in light of the hazards that we identified when we visit. So thus far, we have not issued any prohibition notices, but we have given improvement notices for the rectification of the non-compliance found.
So all these buildings, again, that are currently accommodating the magistrates' courts, have you had these owners, like those buildings that have been leased, provide a fire certificate to say that this building is compliant with the fire regulations?
There are particular items that I believe that fire services, this question is probably best deferred to in light of that, STU.
Perhaps I could ask the fire services personnel. Is it that all the buildings that are currently accommodating the magistrates' court are in receipt of a fire certificate?
Good morning again. All the buildings that occupies magistrate courts, all the justice come down, are not certified at this present time. We have done inspections on the requests, give requirements, but to this date, none of them has met the requirements to be certified.
And to be certified, what does that mean?
To be certified as meeting all the standards that was set out by the fire service in reference to egress, suppression system, extinguishments, signage, those things. They must meet the certain requirements that are given under the inspection because of the occupancy that deals with within the building.
So again, a similar question to what was posed to OSHA. Is it then that you also do a follow-up to see if there is compliance?
Every requirement given, there's a time frame, 30 days, 60 days, 90 days, up to. During those periods, we expect the client or the owner of the compound, whether it's a PRSD, where they occupy someone's private building, to do certain amendments and upgrades. During that period, we will expect that we have communication with the HSE person who is there to give us what they have done. Sometimes we give them extensions, all depending on what they have done and what is outstanding. At present, there's been no communication for the last couple of years on the way forward in these institutions.
Thank you very much. Presdy is here, but from our understanding, Presdy has limited or no involvement in the buildings of the judiciary. Would you be able to tell us what is the relationship between Presdy and the judiciary and the judiciary's facilities at this time?
Okay, good morning again all. Presdy right now agreed we do not have any relationship. What has happened before, prior to their receiving cabinet approval, we would have engaged the landlords with respect to the buildings that they are currently in. In terms of lease rentals, we have been engaging with the landlord. We have engaged with OSHA, Fire Services, Commissioner of Valuations, Town and Country and others to ensure that the buildings are compliant and magistrates' courts can occupy them. However, once Fire or OSH has given their report to us, we do transmit that to the landlord and to the magistrates' court administrator so that they can follow up also. But however, as present, we are no longer involved in their processes.
Okay, so where there were existing leases, that has transitioned to this new standing committee, the responsibility?
Yes.
On the last occasion, the issue of proposed site or proposed building for the Arima Magistrates Court was discussed. Is that still under your remit, or that has passed to the standing committee?
That is no longer under our remit.
Okay, thank you.
Thanks, Chair. Good morning again. A question for use the proper title of the Property and Real Estate Services Division, Presdy. How long has this, has the relationship been with the judiciary and the Property and Real Estate Services Division?
With respect to the Sandy Grande Magistrates Court, we have been having relations with them since as far back as 2004. With respect to ARIMA, it could have been prior to 2013, and with respect to San Fernando, prior to 2008.
It's not as long as, it's not that long in a sense, and I would have thought it would have been.
It may have
80s
been, it may have been longer than that. I did not go that far back into the files, to be honest with you.
Okay. So I wouldn't ask you to go there in today's conversation. Well, then two questions would arise. If Prezi has relinquished this role, would it have been any issue regarding personnel shortages or shortcomings? What would have been communicated to Prezi as the reason for relinquishing?
Our receipt of the cabinet decision with respect to judiciary handling their own lease rentals, their own accommodation, would have relinquished us from our responsibility.
Okay, so it's not from you. And then what happens now regarding, does it mean that you now have a bumper crop in terms of excess personnel to deploy, or?
Sorry to say no.
We can put that one to rest. The question I have, thanks, is really for fire services in terms of the report. I mean, I was going through the fire services report, going through the commentary from the Law Association, and I had some concerns regarding the preparedness of the judicial buildings in the event of an emergency. All right. Can you give us a sense of the regularity within which these buildings are inspected, as well as given like a percentage rate then, and in terms of how many buildings are covered with fire certificates?
Okay, from our records, there is about, well, I know for the Southern Division, we have 6 buildings that we would normally visit with reference to the judiciary buildings. The Northern Division, approximately 9. Right. Based on the OSHA Act, Part 5, they require those industrial establishments or those buildings to be inspected every 2 years. The inspection process, we do a risk assessment. We look at code requirements to see whether or not there are adequate means of escape, fire protection system, training to the staff, evacuation exercise are done so that the staff will know exactly what to do in the event of an emergency. We would have done those inspections in the past and would have given requirements. We liaise with at the moment, the OSHA manager for the court, who from time to time gives us feedback on the requirements and at what state they are at. From our observation on the inspection, they have what we may call some of the minimum requirements in place. So for example, the courts that we would have visited, they had primary and alternate means of escape. They were signed, they had fire extinguishers in the building. Those courts that require fire alarm system, sometimes they will have that fire alarm system, but it is inoperable. So we'll give them an improvement notice to have it made operable. We would have done in the fire department fire safety lecture to the staff at the court. So they are aware of what to do in the event of an emergency. And we also work with them in creating what you call evacuation plans for the court. If we observe other fire hazards like improper storage practices and so forth, we'll inform them immediately. And those are some of the hazards that they could remove immediately. So from our experience with the court, they have a level of responsiveness. They have a level of safety training. And with the coming on board with their OSHA unit, Internally, they also do lectures and fire drill also. From my recollection, about 2 years ago, we would have done all the buildings, the judiciary buildings in the Southern Division in terms of supervising our fire drill. So at times, we know that the challenge for resources may affect the implementation of some of the more costly requirements. But in my humble view, the occupants of those buildings in the Southern Division, and by extension, probably the Northern Division, they have that minimum level of fire safety training to be able to identify hazards, remove those hazards, and in the event of an emergency, know what action to take.
Thank you very much for that, that explanation. I want to invite the OSHA authority to join the discussion in relation to your experience with the Magistrates Court and anything you wish to highlight to us.
Good morning again. The Magistrates Court, the OSHA has been around since 2007. And we have had a serious staffing issue in terms of how many inspectors we would have to then send to inspect certain places. We have a program where, as the CI had mentioned, is based on risk and the risk of the industry to life and limb of people who work within them. And in this country, we have a lot in oil industry, we have construction. So many times when we do our profiling, those are the industries that would then get the attention of the minimal amount of inspectors that we do have. Until recently, we only had we have an approved structure for 48 inspector ones. Until recently, we only had 16. So we had to then try to get to deal with the higher risk businesses rather than go to places like the judiciary. With the judiciary, though, we've had to seek permission to get into those areas because of the nature of the business. And unless we see that is something that is imminently dangerous, that's the only time that we would seek to shut down any building, responding to your question earlier on. Because of the nature of the judicial business and the domino effect it has, if we shut down a courthouse per se, then matters would not be able to be heard. And then we would have a backup within the court system. So we try our best to see how we could help to improve whatever the conditions are without shutting down the building. Recently, we've had, because of our last appearance at JSC, we've had funding to get more inspectors. So now we're up to, I believe, about 29 inspector ones, and we filled our inspector 2 positions and also our senior inspector positions as well. We still have vacancies, and we put an ad out in May, and we're looking to interview to fill up to get to the full contingent between now and the beginning of the next financial year. So with the program we currently have, we would focus on the judiciary some more, and we would help them in terms of getting them to a place where they are compliant. Bearing that in mind, some of the buildings are very old. So there has to be some consideration also for maybe just moving buildings, or that's a bigger decision than us. But we will look at the buildings individually and see what we could do to help them improve and get to the point where they are safe for people to operate within.
Follow up with that, the response. If a building proved to be hazardous to the users of that building, why is it then that you may need permission from the internal OSHA unit from the judiciary if that building poses a risk? Why is it that OSHA, I think OSHA is an independent body? It is governed by some act?
Yes, it is.
Right.
Mm-hmm.
So is it then that you could move in, as the one for a better word, or why it is that you need that permission to be granted before you could move in?
It is true, we could move in. I think in the past there was one incident where inspectors went to a particular court and they were told they couldn't come. I think those inspectors probably were not aware of, or they didn't try to enforce as strongly as they should have. But according to our act, we don't need permission. But in this situation here, where we're trying to do proactive inspections, and because we see no imminently dangerous conditions, we're trying to work with the court now so we can schedule our visits so we wouldn't disrupt the court. But if we do a risk assessment and we notice that a building is imminently dangerous for people to be inhabiting that building, we will move to close that building once the risk assessment tells us that it is imminently dangerous.
And I could ask and get the probation officer here involved, because from your submission, you have said that there are inadequate space at the magistracy, which has created physical and environmental health and safety issues in the workplace. So perhaps you want to elaborate on what are those environmental issues, and if you had made any formal complaint to the judiciary. And the OSHA agency also, huh?
Okay, probation started in 1947 under the guidance of the magistracy. So at that time, we were actually given office space in most magistrates' courts across the country. That has not significantly improved over time, and what we have done, if we have environmental concerns, is that we will talk to the clerk of the peace in the court. Because of protocol, we will not supersede how we are supposed to operate. So what happens is that through the clerk of the peace, if we do not get the requisite response, then we could take it to, I have actually been moving up higher, which I don't really like to do without permission, but through our PSs, I have written to indicate that we need our own autonomous space since 2015. So the environmental concerns really is if we have officers, we have community service officers and probation officers and support staff, sometimes crouched in maybe one or two little offices, which is at the Arima court. That is one significant example. The photocopying machines and all those things, I know those things they are health hazard, especially if you have to sit in a room with the microwave and the fridge and that kind of thing. So those are the kind of things that we deal with as far as the infrastructure is concerned. Apart from that, we have issues with clients, because we have a significant amount of fairly volatile situations that we deal with in terms of domestic violence situations, in terms of just aggressive clients. So we have to always be very careful. We do not have the type of sit-in arrangement that is for our safety. So sometimes you are in this room with, you might have the security outside. So it is very difficult to try to maneuver. So I guess out of our professionalism, we have to be able to deal with our clients for our own safety. So we have a lot of those kind of things to deal with.
When you have written to the OSHA unit, you got any response?
I didn't write to the OSHA unit. We wrote through my permanent secretary, we would have written to him to ask for, to PRESD. And I think what PRESD does, from my understanding, is that they will have all the requisite approvals before we could get the accommodation. But one of the challenges that we face is that probation services we have had like over 10 ministerial realignments from 1947 to now. So when you try to get something done in one ministry and then you move to another ministry, you have to start it over. So that has happened. In 2015, I wrote through the PS, and I would have been following up via emails and telephone conversations, and I even went into meetings with PRESD, but I realized they have significant staff issues too. So on the last occasion, we were given 2 real estate agents that we should try to access, We spoke to them, and I think they were having some, what we were told is that there are some issues regarding the renting for government offices because of payment and the approvals and that kind of thing. So right now, we are still waiting. Apart from Point Fortin, which seems to be pushing through, we are in the process of obtaining one office in Point Fortin. So that has gone pretty recently through our facilities manager, Ministry of National Security. So I'm hoping for something positive, at least with Point Fortin so far.
Member Obika.
Thanks, Chair. The question I have is for, I would guess, all takers, but in particular, the OSHA agency. What weight is given to, in an inspection, the state of the washroom facilities? Because the Law Association complained about the Port of Spain Magistrates Court on the second floor. And because of the unsafe conditions of the washroom facility, it causes persons to use facilities elsewhere, which again could cause issues in compromising the whole process of the court because persons have to leave and so on. But besides that, the persons who can't leave, they have no choice but to use those facilities. What weight is given to washroom facilities in an inspection?
As it relates to the washroom facilities, what we would look at is the amount of personnel that will be required on whatever level to utilize that facility. If what we look at also is there's a WASA regulation that speaks to 20 people per washroom facility, which in itself, but that is one of the pieces of documents we also look at. Saying so, however, if the facility as it stands is insufficient, it's in a poor state, we will include that as part of the improvement notice procedure and issue a notice to the Magistrates Court and give them that timeline. So that all the notices, improvement notices are timed. So we can vary, based on that timeline for action.
Now is this. I would imagine, but you can clarify if I'm wrong, that there will be instances where buildings will be closed because the air conditioning unit is not working, if it's centralized air conditioning. If there is no water in the building, would there have ever been instances where a building is closed because of the state of the toilet and washroom facilities?
We haven't had such a report, but it can be until that is rectified.
Then would be, what would be the, if of course this metric is available, what would be the ranking of the washroom facilities in terms of buildings with acceptable and buildings without acceptable washroom facilities currently in the magisterial district?
Clearly, welfare is one of the items as established within the Act, and it's one of those must-have, responsibilities of the employer as well as the occupier. Clearly, if there are no washroom facilities, no water, you will rank that as a higher level in your inspection program, and action must be taken.
And I have a question for the probation department. Because you're users of these buildings, occupiers, then the washroom facilities will impact heavily, I can imagine, on worker morale and so on. But can you give me any indication as to what is the sense amongst the staff of the washroom facilities?
Well, I think generally there is the feeling that we should have our own washroom facilities because of safety issues, and I could agree with them. I definitely agree with them in this case, because sometimes it's difficult. You do not really want to go to a public washroom with your client who might be upset with you for whatever reason, especially like in custody matters and that kind of thing. So we always have to be very particular, and I think it makes sense that we have our own washroom facilities.
Then, has there been any instances in the past where persons have been, if not physically assaulted, verbally assaulted by members of the public?
I can recall verbally assaulted. I think that is where a number of officers would have had certain issues, but not physically, as I'm aware.
And then it begs the question then, because to me, if I have to go to work and I have to feel safe, I don't want to be in an enclosed environment where I'm threatened. You know, is there anything that can be done regarding this in the short or medium term if you have to stay in the same building? So probably the addition of an external toilet for public users and a separate one given the current buildings that you're in for occupiers.
I think given the current buildings, it will be difficult to do that because I know space is a major issue because even in terms of dealing with car parks, it's a problem. So it might be very difficult to put an annex or something to that effect. But what they could probably do is designate one particular washroom facility to probably like probation services and probably the legal officers, something like that. I can't think about adding anything anywhere. It is.
Just one question to OSHA. Do you have any vacancy for a chief inspector, or that substantive post has been filled?
There is a vacancy. The current chief inspector is performing duties until we fill that vacancy. That was one of the vacancies that was advertised in May. So we're currently shortlisting for interviewing soon.
The question I have has to do something that came up in the past. There's asbestos in the ceilings of buildings, public buildings. Is that a problem? And this is for both fire services and OSHA. Is that a problem in the judiciary buildings of the judiciary?
We were aware of one report of asbestos that was reported at the San Fernando court. That facility has since, as far as I'm aware, been shut. And when reports of asbestos has not been brought to attention, now we must be aware of the time frame of the erection of new facilities that would have actually been built thus far and is being occupied by the magistrates' courts. As far as I recall, anything after the 1970s, the use of asbestos was prohibited for insulation, for roofing material. So anything prior to that, it's a concern that needs to be looked into.
Okay, thank you very much. In terms of the objectives of the committee, the second objective is to identify the progress that has been made. And my assessment of this morning's proceedings is that some progress has been made. In closing, in inviting you to make your closing remarks, I just want you to focus on this issue of progress and to give us your feedback on your opinion on the progress that has been made in relation to the Magistrates' Court. Can we start with fire services?
Yes, well, the fire service is always willing and ready to respond to any request from the judiciary or any occupancy or any owners, any premises in Trinidad and Tobago. For my dealings with the OSHA team at the judiciary, we schedule, as I said, we schedule inspections. In our opinion, there are no imminent, we have not observed any imminent danger at the facilities that I would have inspected or my team would have inspected. We are seeing where they are complying with the requirements that we would have issued. However, on certain occasions, they may have some engineering works to do, they may have some remodeling to do at the particular premises that they would require additional time. And they would invite us also to give further requirements. when we issue those requirements, it will take a little time for they to implement those requirements based on cost constraint, budgetary allocations, and or so forth. However, what we do, we try to be proactive with them and give us some of our institutional intelligence in terms of if a particular fire protection system is not working, what are some of the measures that you could have in place as a backup to ensure that there's an adequate level of safety in the building still. So we continue to work with them. We continue to be ready to give whatever advice. As I said, we have planned to do some spot inspections also. In the fire department, we have stations, and the FSO in charge of those stations also are required to visit those public premises to gather the necessary fire safety intelligence to develop what we call emergency response plans for those facilities. So at times we may not, the fire prevention section may not go on the inspections, but they will do their familiarization tours to ensure that they could also give advice where possible and to create that emergency response plan for that facility.
Okay, thank you very much. OSHA?
In terms of progress, over the last 2 years, we have made significant progress with regards to how we inspect. We've made significant progress in terms of the amount of inspectors that we've now hired. We've also made some progress with regards to our collaboration with other type agencies who do similar regulatory type functions as we do. We have an MOU that we have established with the fire service now so that we could do joint inspections and we could then share information so that we could not, be doubling up on the work rather than doing one approach. We've developed over the last year or two programs where we could identify the risks within buildings and the industries as to how risky they are. So now we could plan our programs better and be more proactive rather than reactive. We've formed some communication with the court. So with this situation, with the magistracy and their buildings, we can now plan proactive programs. There's some things that are outside of our purview in terms of the building itself and whether or not it probably needs to be totally abandoned or not, but we have more communication between us so that we could then give them some of our expertise, give them some guidance, and also protect the workers. So there's more cohesiveness now over the last 2 years or so. We've also got more inspectors, so we have a wider reach now. So I think there has been progress in terms of the agencies not working in silos, but they're working together so that we could have, better outcomes all around. So we're looking forward to see how that will work in the coming months. Thank you.
Thank you very much. Probation Services?
Well, progress for probation is, as far as accommodation goes, is really for us to get our own accommodation and be autonomous. However, we have to look at one of our basic needs, though, is to be within the precincts of the court or in close proximity to the court, because we could lose a lot of clients that way if we are not close by, because we do not have a vulnerable population. So in the interim, I am happy that I was here to be part of this forum, because some of the major people who I need to be in constant communication with actually sitting around the table. But we have gotten approval for additional staffing, so to ensure that we are effective, we need to make sure that we have our security is of paramount importance, because the risk of our clients has also increased over the years, and with gangs and bail supervision, etc. So all these things must be taken into consideration when we are being housed in any jurisdiction. Thank you.
Okay, thank you very much. In closing, we want to advise the public that the following inquiry reports were recently presented to the House of Representatives and the Senate and are now available on the Parliament's website. The first is the 5th report on a critical assessment of the waste management policies and initiatives of the state, with specific focus on solid waste. The second report is the 6th report on an inquiry into the implementation of the new public procurement system. I want to thank the committee members who are here with us today, the support staff, the media, anybody who is in the public gallery, And of course, I want to thank the Secretariat, who is always here with us to support us. I want to now adjourn this meeting to a date to be fixed. Thank you.